Welcome to another episode of the Coffee Conversation Show powered by the Emerging India Forum, TEIF, and our tech partner, Prime Infotech Solution. Series is The Emerging Lawyer. Theme is Patents, Progress, and Passion from Inventor to IP Strategist. So, friends, we have with us Parvez Kudrolli, Principal Associate at Khurana Khurana, Advocates in IP Attorneys. Parvez has a remarkable journey in the world of intellectual property. He has 2 decades of experience in patent law. Parvez has secured one of the first software patents for an Indian company in the US. And he's become a trusted strategist for innovators and IP creators across the globe. So, friends, it will be a lovely conversation having with Parvez, who is a seasoned inventor, patentee, entrepreneur, uncovering challenges, successes, and this is an ever-evolving landscape of intellectual property landscape. So, Parvez, welcome to today's Coffee Conversation episode.
Thank you so much, Amir. It's great to be here. It's a pleasure and honor. And greetings to everybody. And welcome to this session on patents, progress, passion, IP strategy, and so many things related to this. Look forward to having this conversation.
Okay. So, Parvez, I just wanted to explain you the format. There are 3 rounds. One is professional journey, second is personal, and third is a rapid fire round, which you are not aware. So there is
Okay.
a rapid fire fun round, for
Right.
which you get to win this book, Shaping Indians.
Okay. Great.
So, friends, I am Lion Amir Virani, your host of Coffee Conversation, legal tech evangelist, and author of 15 ebooks. So let's begin. My first question for you, Parvez, what inspired you to pursue a career in intellectual property law and innovation protection?
What inspired me was we were actually involved in working in this area, not initially on the legal side, but initially as an inventor, as a software developer inventor. And once you come up with something new, some new piece of work, then next thing you think about obviously is how do we protect this? Because everybody who's developing something, creating something, inventing something, they will think of, okay, this is really great work that I've done, this is my baby, I want to protect it, I want to make sure other people don't misuse it. So that's when we thought about protecting, and that's how we became aware of IPR and patents. That's how I started learning about patents. Then we prepared and filed our own patent applications. And just filing an application and getting a patent registered is not enough. You after that you need to sell off those patent rights that you get, that you develop. You have a certain kind of a property which is called intellectual property relating to ideas and technologies. And then you want to commercialize it. You want to either sell it, license it, or make money out of it. So having gone through this journey, not only from the legal side, but as a technical worker, as a person developing some software, inventing, creating new things, then looking to protect it and then to sell it. Going through this experience, I thought it would be a great thing if I could help other people who are getting into this journey, which is in a way, if you see this domain, it's like a multi-domain expertise is required, which is technical, legal, and the business angle of it. That's how, I was inspired to work in this.
Okay, that's an interesting journey. So now let's go back to your early days of your first software patents, which an Indian company did in US Patent and Trademark Office. So how was the experience? How does one go about registering your software patent? So for our viewers out there.
Okay, now there's a lot more information available to people who want to go about. Lot many firms work in this. They are like very experienced and have good expertise in doing this. But and so basically, you need to put it very briefly. How you go about is when you have created a new technology or an invention, you have to prepare a detailed technical description and drawings which help explain the invention. Based on that, you go to a person or people who are good, experienced, skilled at drafting and filing patent applications, and these could be patent attorneys like our firm Khurana and Khurana is, or it could be somebody who's like experienced, worked a lot on not just the technical side but also on the patent legal side, and they have good experience, go to a person like that and have them draft the patent specification and then file it with the patent office. This I'm telling in brief. Okay, I'll expand on it a little, but briefly speaking, describe the invention means don't come with an idea in your head or all kinds of ideas going on in your. That's not enough. You need to put it on paper. If it's not on the page, it's not on the stage. So document it such that somebody else reading that document and looking at your drawings can understand what that invention is. And that somebody else I'm referring to is the patent attorney who would be working on your patent document. Okay, if they don't understand your invention, don't expect they'll draft and file a good patent specification. No way, right? So that's the first thing, and that's basically what you need to do. Now there are further details to the process, etc., which is available on the net, but I'll not go into that now because it will take too much time, and that's not really the focus of our discussion today. But now, having quickly told you how do we go about protecting an invention, through a patent protection, an IP right called a patent right. Okay. So I can, as you asked me in the beginning of this question, I'll go a little bit into how we got started off into this, how we became aware of this, how we started working, what did we do, and how did we file the Indian application and then the US, and then got them granted, one in India and two in the US, right? So I'll just come to that. Firstly, as I mentioned, because we create some technology, the next thing we do is we think about protecting it. Because what we saw, we had a small family startup kind of a setup. We saw that this product, once we develop this technology, once we come up with, we don't have the resources, okay, either the money, the facilities, or the marketing network to make an end product and sell it in the market. And so we were wondering, what do we do with this? We develop this, but we don't have the resource to actually make and sell it in the market. Then we thought, okay, why don't we protect the idea itself, the technology itself, get some right on it, and then give that right to whoever is willing to invest in, making it on a commercial scale and selling it. So that's how we got thinking about we need to file a patent to protect this thing. Okay, and very frankly, I'll be very frank with you. At that time, we had heard that patents can protect ideas and technologies, but we didn't really know much about that. Luckily, it so happened at that time, luckily, we had a family friend visiting us from the US. He himself is, one is he's a technologist. Secondly, he's been a researcher at IBM US. Thirdly, he's a lawyer. Fourthly, he's a patent attorney, of the highest grade. Dr. Vijay P. Kesan in the US is known as JP Kesan. So he was visiting us, and let me mention this. He is my patent guru. He taught me about patents. The entire framework about IPR and patents that I have in my mind is, I have to thank him and give huge credit to him for that. Even today when I work with people, innovators, and guide them on how to approach things, have simplicity and clarity. See, people talk long, complicated things. The inventor doesn't understand what are you talking. How to communicate the critical aspects very simply and in brief. I remember the things that he taught me, he guided me, and he told me even today, and that helps clarify things a lot for people who do it. So, I owe many thanks to him for guiding at that stage. We met, and then we asked him, "Oh, what is this patent? How does it help? Is this really useful? How does it work? And what do we protect? How do we know what is an invention and what is not an invention? And we are doing so many things in our software program. Which part do we protect and patent, and how do we describe? Do we need to give source code, or do we need to give a English description? Nothing of these, we had a good sense. We asked him about it. And then, that's how we became aware of this. We started working on this. We started thinking about this, and gradually discussing with him. Plus, I went into the patent law. I used to visit the patent office. As you know, I'm based in Mumbai. So I used to visit the Mumbai patent office, which at that time was at Lower Parel. It's not where it is now at Antop Hill. And that patent office was the top floor of an industrial estate there, Todi estate, old style kind of a thing. No, not much of computerization. I used to go there, and the security was not like it is today there. They would actually allow people, inventors, to go and meet up with the deputy controllers, examiners, ask them questions and understand. So that's how I learned about this whole thing. Okay. That very frankly, when we got into this, we didn't know what we were getting into. Okay. We had no idea how tough, how difficult. Sometimes I think if we had some idea of how difficult this is going to be, how long it takes, and how much resources it calls for, maybe we would not even have started into this area. But thankfully, we didn't know, so we got into this thing without understanding. So we were actually originally working on some other software systems related to managerial accounting. But certain problems we faced related to how to display information in compacted spaces. And just to show as an example to Dr. Vijay Kesan, we showed him this thing. Suppose we come up with something like this, how do we file a patent on it? How do we know which part of this is the invention? How do we describe it? What do we do with this thing? We asked him that question. So he started explaining. And one of the things he said is, look at this. This itself possibly is an invention. It's a small thing, but it could have wide application. It is a small feature, okay, but it will fit into maybe thousands or lakhs of software programs potentially, right? So that's when we got working very seriously on refining or improving that particular initial idea that we had for an improved process for compacting information. So that's how we came up with our first invention. With the help from him, we drafted and filed the Indian application, and subsequently we also wanted to protect this technology not just in India, because if we file an application in India, you get only an Indian patent, which is valid only in India. We wanted to protect this in foreign countries also, especially US. We knew even at that time, this was the late 1990s and early 2000s, right? We know that US is a critical development center and market for software. So we wanted to file a patent over there. We learned about it from there. I would go through the Indian Patent Office website to understand the act, rules, the law, the US Patent Office website, the system there, how they process it. All these things we went through. That's how we came up with our first invention. We got the patent specification drafted, and all the forms and stuff I did myself after speaking with all these experts. And I went and physically, nowadays the filings are online much easier. Physically, I went and filed those copies, paid the fees there, and started the process for that thing. Okay. And then what happened was when the application came up for examination in the patent office, among other usual objections that the examiner would raise, the one problematic objection they raised was, in India, as per Indian patent law, patents are not granted for software related inventions. Software process inventions are not patentable because world over, and especially in India, the question of whether software is patentable was very much open, right? Now, what had happened is through the late 1990s and early 2000s, the law in India was amended to make it TRIPS compliant. India became a signatory to TRIPS, and as per that agreement, we had to standardize our patent laws in line with whatever is practiced in other countries or whatever is mentioned in TRIPS, which means you can't deny patents to a particular area of technology. You have to deny, you have to give patents if you give for all technology areas. So you can't say for everything we'll give medical, mechanical, electrical, but software technology, which, and everybody will agree it's a technology, we will not give a patent. So therefore they had to amend the law, right? So they had amended the law. There was delay in it, but by the early 2000s, they had amended the law. But then the examiner rejected our application finally on the grounds that it's a software process invention. Therefore, we cannot grant a patent on this particular thing, even though by then the law had been amended. But then examiners at the patent office, controllers, they are cautious people. They don't want to be the first to grant a patent in a technology area which nobody else has done, because somebody might blame us. No patents have been granted for software. How come you have granted? What was the reason? So they were concerned. So that's why they didn't grant the patent on that. So then after that, we actually filed a case against the controller of patents in the Bombay High Court, and that case went on for quite a period of time, maybe a year or more than that. Basically dates, and in the between we have to make arguments and written submissions have to be given at the patent office. Then the controller, a copy is sent, and then they will give their reply, they will file that, then we counter that, etc. So this was going on. In the meanwhile, the government set up the Intellectual Property Appellate Board, which was set up in Chennai. So then midway, the court, Bombay High Court, the judge there transferred the matter to the IP Appellate Board in Chennai. But the problem was, even though the appellate board was set up technically, actually it was not actually working. So it was set up on paper, but was not operational. Then again, it happened. It so happened that about a year or two went by, it was not operational. Then it became operational, but it was not functioning for patents. It was functioning only for trademarks. Then again, time passed, and later on it started operating and handling matters and cases related to patents. But in the meanwhile, unfortunately, we lost track of the whole thing, and that patent was stayed in a rejected state. We didn't get. Okay, so this is what happened with our first invention. In the meanwhile, we had filed a US application. We had filed a PCT international application, that is a Patent Cooperation Treaty international application, which helps you, based on that initial filing, to go and file corresponding applications and protect your invention in multiple countries. You get extra time. Under the Paris Convention, when you file an Indian application, you get 1 year's time to file in foreign countries. If you want more than 1 year's time to decide about and do foreign filings, and by the way, foreign filings are quite expensive, so you can't take it lightly and do day one, I'll file in 50 countries. Nobody, not even multinationals, does do that, So by doing Indian filing, India is a signatory to the Paris Convention. So you get 1 year's time to do foreign filings. Now, many inventors and developers feel, oh, 1 year is too less. We are still developing the product. We haven't launched it, or it's still not doing well in the market, or we still need to work on this, right? We need more time than 1 year to decide about foreign filings. In that case, what you can do is file a PCT, international application, Patent Cooperation Treaty, international application. That gives you an additional 1.5 years to do foreign country filings, and you can choose those countries within that extended timeline of 1 year plus 1.5 years, right? So we had done that also, right? Eventually, the US patent was granted. Indian, as I told you, the story was not granted. In the meanwhile, we also worked on a second invention, which was related to this, but a different invention, which related to compacting information arrays. So we filed that in India. We filed that a little later, within 1 year, in the US. By then, we learned one thing. No point filing the PCT application, because you incur expenses on the PCT, and later on you have to incur expenses for filing in foreign countries, which is a lot of money. We didn't have those resources. So for the second one, we filed the Indian, and then we filed only the US application for that. And when the Indian application came up for examination in the Indian Patent Office, okay, the usual objections were raised, but they didn't really raise a serious objection about software is not patentable. This time they granted the patent after the due process of examination. Okay, so we got our first Indian software patent granted, which was one of the first probably software patents granted in India, because as we saw, the patent law when it comes to software patents was in a state of flux at that time, and my earlier application was rejected. So I would like to believe that all the arguments that we made, all the submissions that we made in Bombay High Court, putting forward our side of the argument and explaining why software should be patentable, what is the Indian patent law, what is the relevant case law. We didn't have case law in India. We had to go to UK and Europe and look at case law from there to actually convince and argue effectively that this is why a software patent also should be granted in India, and we got that granted, right? So the first Indian application software rejected, second one granted without trouble. Both the US patents we got granted when we filed there. So that's how we came to this position of having, the Indian and US patents granted. And the US, when it was granted, was one of the first granted to an Indian company based in India. Okay. Because if you actually look at the US Patent Office databases, every second and third patent, you'll see for the last so many decades, you'll see an Indian name. Every second or third patent in the US, different technology areas. But an Indian company based in India getting a US software patent, I think we were among the first to do that. There was one other company, which was a subsidiary of Texas Instruments in Bangalore, which had got the first one, I think. But that again is a subsidiary of Texas Instruments, not really fully Indian company.
No, interesting. So Parvez, you have been on both sides of the fence. Like you have done your IP protection for your innovations, and now you're doing IP protection for your clients. So there must be some cases where the clients must be acted fussy. So share some examples, some stories, and some memorable experience of IP protection for some innovative software inventions.
Right. Okay. Yeah. So I can hear an echo there of my voice again coming. If you could just cut that out. Okay. I'm getting to hear that echo. Now I think it's gone. Yeah, it's okay. Yeah. So coming back to the question. So I'll share one of the challenges that we face when inventors come to me, okay, with their invention, their thinking. I have a certain understanding, they have a different understanding about patent law and IPR, and some of the difficulties that are faced because, and I'll use an example to illustrate this aspect, okay. The critical thing when we are talking about an invention and protecting an invention through a patent is, first of all, there must be clarity about what is the invention. There has to be a proper description and drawings explaining what is the invention. Now, very often, right in the beginning, this becomes a challenge. Okay. And let me explain to you using an example. Okay. Imagine that there is an existing product or a technology that is already known. Now somebody is improving, coming up with an idea for a better version of that product or technology. Means existing technology, you're adding some feature or some part, some aspect to it to make it a better technology. And that improved product or technology, then you will want to patent because that improvement part is not known. Okay. Now I'll take the example, for example, of a container or a glass or something, imagine. So imagine that this kind of a glass or container or cup is known, but what is not known is a cup with a handle. Imagine this story is based, say, 100, 200 years back. So a glass container to drink liquids is known, but a container with a handle is not known. So some inventor is now coming up with the idea for a container or a cup or a glass with a handle. That's the invention. Glass is not the invention, but a glass with a handle attached is the invention. The question that arises is, if I want to patent this idea relating to a container with a handle, what kind of description do I need? What is the exact invention? Is it the glass? Is it the handle? Or is it the combination of the glass and the handle? How much detail, inventors ask this, about their invention. How much detail do I need to provide about the invention? How do I describe the invention? Do we need drawings for this? So these are the questions that very often arise. It becomes challenging. Okay. So one person might come and say, okay, my invention is the concept of a cup with a handle. Okay. And that's my invention. Now, this is what I want to patent, right? And then we'll say, okay, fine. The invention is clear. Just give a description. Maybe it's a few lines or half a page or something. Give some drawings of some sample implementation. One implementation is a brown ceramic cup with a handle. Another could be a copper glass with a steel handle. Okay. So give some example of how you actually implement it, and then we'll file a patent on this. Okay. So here is an inventor who is looking at the broad invention concept, as in he is saying that my invention is a cup or a container with a handle. Clear. Okay. On the other hand, we get some other inventors who might look at the same invention. They've created the same invention, but how that person describes his invention to me is, my invention is a brown cup, okay, which is made of ceramic material, to which is attached a brown handle which is made of wood, and the height of this is 5 inches and the diameter is 3 inches, and the inside part of the cup is white in color. Okay. Now, same invention. Okay, did you see the difference in how the inventors are describing it? One invention is, inventor is describing the invention as an idea, as a concept, without limiting to it must be made of this material or it has to have this color or that size. No, they're saying anybody takes any container of any size and attaches a handle, that's my invention. And they're infringing my patent if I get a patent on that. The other guy, can you see, The second inventor is actually has the invention concept, but is looking at that very narrowly in terms of the implementation detail. Okay, it must be the cup is ceramic, brown on the outside, white on the inside, the handle is wood, it is brown, and the height is 5 inches. These are not invention details. This is not part of the invention concept. Invention concept is cup with a handle. What this person is talking about and is getting lost in are the implementation details, right? Because if I write a claim listening to the second inventor and all the details, because he is also justified in saying these details have to be given, because if somebody wants to manufacture this cup, they should know, no, whether it's ceramic, whether this is wood or not. Because a theoretical material, there is no theoretical material you can make a theoretical cup. When you are making, you'll have to decide either ceramic or wood or steel. You'll have to decide, right? To implement it, you need the details, but they are not part of the invention concept. So listening to the second inventor, if in my patent application, in my specification, I describe it with all these details, and then I write a claim like my invention is a ceramic cup which is brown in color on the outside and white in color in the inside, and it has a wooden handle which is brown in color, and it is 5 inches in height and 3 inches in diameter. If I write a claim like that, guess what happens? And the patent right I get is based on the claim wordings which I've described. So if this person, right, thinks this is my invention, including all these implementation is my invention, and they make us also write, they don't listen to us, no, express it broadly, they make us write like that. Then what happens is, if he gets a patent on this brown cup with white inside, ceramic, 5 inches, wooden handle, he gets a patent on that, okay? And tomorrow he sees that somebody else has copied his invention, in the sense that they have taken a cup which is 5 inches in height, 3 inches in diameter, but the cup is pink in color and it is made of steel coated with pink color. Okay, and the handle is not wooden, but the handle is made of, say, ceramic material, right? Now, can you see the broad idea of a cup with a handle? They have copied this person's invention, but this person claimed a very specific implementation only as his patent right. Therefore, the person who's not following these implementation details but following the concept only can avoid infringing this guy's patent. So this guy has got a patent on this very specific with detail, color, size, material, all that patent is there, but he can't implement and enforce it against any person who's copying the basic concept. And what is the basic concept? A cup with a handle. That's really the innovative concept. Which material everybody knows here. You can make a container with ceramics, wood, steel, copper, brass, blah, blah. There's nothing innovative, but they're putting this detail into it, right? That is problematic. That way, you might even get a patent granted, but it's not enforceable. It becomes very easy for the person or the company or entity which wants to copy your concept to copy the concept, change some of the implementation details, and therefore avoid being sued by you as being in an infringer. You get this concept? Now, the way this example I'm explaining, it looks very simple, this idea, right? But it's amazing the kind of inventors we get, okay? And how they talk and how they are like, so into their baby, this is my baby, this is my invention, it has to be done like this, okay? I'll give you 2 examples. Imagine there is an inventor, okay, who's not like very high tech or very highly educated skilled, but he's on the ground making certain kinds of products. One day he gets an idea to improve some aspect of the product, okay? And then usually when, a person like that comes to us, she might very well say, okay, this is an existing product. What I have done is improved this part of it by either adding this improved part or changing the design or shape, such that this problem that we were facing, now that is solved by having a modified or improved version of the thing, right? And this is how it is. They might give a very brief description, a few lines or half a page, 1 or 2 drawings showing which part has been changed, okay? So this kind of thing, one can see that they are very much on the ground and they are clear about what is their invention and what is the invention concept. For example, they come and tell, such a person will say, my invention is a cup or a container with a handle, okay? And that is what I want to patent, because till date, all the containers don't have handle for drinking. Now my idea is put a handle on that. This is my invention, okay? So then it becomes very easy, because now as a patent attorney or somebody is going to work on the drafting the specification and filing it, very clear to me what is the invention. And I can see that this person, inventor, is claiming and getting a right on the broad concept of a container with a handle, right? Without getting stuck with the implementation detail. On the other hand, we get highly educated, skilled, qualified, very brilliant, intelligent, and technically very skilled people. They'll come up with very complicated high-tech inventions. Okay. In fact, they'll make entire systems, the end product that is sold in the market with many different features and many parts, and it has many innovative aspects. Okay. And then what they will do is they'll insist on describing the entire system in great detail and claim that the entire product or the entire system is my invention, when actually most of the things that they are doing in their invention are commonly known. Everybody knows, all their competitors are practicing. What they have done is, in this very complicated high-tech product or system, they have changed or added one or two or three parts or features, but they insist on giving a description in great detail, specifying the implementation details, like the example I gave you of the cup, where size, color, material, etc., those kind of details are given. And then, because these people are so skilled, educated, qualified, and intelligent, it's very difficult for us to convey to them and make them understand and accept what we are saying. That the more detail you give in a patent application and in a patent claim, the less the patent right, monopoly right, that you get. Describe, express your idea of the particular part in broad language, irrespective of how it's to be implemented. Implementation details can vary, but express the concept broadly, capture that so that anybody practices that concept at a broad level. The implementation details they might change, but broadly, if they're following this concept, then they are infringing your patent. They say, no, that's not my invention. My invention is you have to do like this, all these, and they have added so many different features. They worked so hard on it for months and maybe even years. They don't want to let go of these details. So then becomes very difficult to get them to focus on specific which part of your product have you improved. Just claim that. Okay. And don't get stuck in claiming too many implementation details. The more skilled, educated, qualified, and technically brilliant the person is, the more difficult it is for us to convince them to look at it from a patent standpoint. I'm not telling them that when you make and sell the product or implement it, forget all these details. No, while doing that, you have to do that, because that's the kind of end product that you'll sell in the market. You'll have to make it complete in all respects, right? But when it comes to patenting, your view has to be different. You need like the 30,000 feet view overall. Okay, what's the inventive concept, rather than what are the details of implementing it? You have to capture the inventive concept. If you do that in your claims, anybody who practices this concept while changing the implementation detail, they infringe your patent, and therefore you can enforce this against more people and collect revenue or license fees from more people. That adds value to a patent. This is the basic problem that I face. For normal people with basic on the ground working, something practical, simple solution described simply works, they understand this concept. The more brilliant, more skilled, because people, they're very difficult to explain, because their training is very detail orientation. And even if I tell them, okay, for a moment, take off your technical expert inventor hat, put on the patent protector, patent examiner, patent attorney hat, think from that point of view, it's still very difficult for them. This is the challenge that I face. Okay. So I hope this aspect is clear. This is a critically important aspect as to what exactly is your invention. How do you view your invention? Are you looking at the broad concept, or are you looking at it too narrowly? That is very important. Okay. Regarding one of the memorable experiences that I've had working with an inventor and on a patent is one of the examples of a product where the inventor came to us with the idea, and we discussed with the inventor in good detail and got the description, etc., drawings, and then we drafted the patent specification, including the claims. And the specific inventive features that were mentioned were put in the claims. And later on, once the patent was granted, okay, the inventor again came back to us, the inventor and applicant again came back to us and said that, what, a competitor of mine is actually making and selling a product similar or same as mine. Okay, can we enforce this against them, right? Now, we would like to immediately say, yes, yeah, come to us, give us the case, and we'll do this. No, but we have to do due diligence before saying that, okay, you have a fair chance of being able to enforce this against them. And when we did that due diligence, actually, I could actually the client could provide images of the other parties, the infringer's actual machine or product there, and I could actually draw, on the drawing point out, looking at the claims of our client's patent, what is written claimed as my inventive features, each of those features I could actually map to that drawing on that this part is as claimed here. This claim is over here. This claim is over here in the infringing product, right? Which means it is a worthwhile thing when there is because you are looking to commercialize and stop others and make money out of anybody who wants to use that technology, right? Here was a case not just inventing and getting a patent, but in a situation where somebody else is using that technology. Okay, competitors, people are using. I myself am manufacturing and selling. It's benefiting the world out there. People are benefiting out of this technology. And here we are actually able to enforce a patent and get some value out of the patent. So this was one of the memorable things. A lot of other cases I won't go into. This is especially when you clarify the whole concepts about what is an invention, how best to protect it. These things, in my view, at least adds a lot of value, and I get a good feedback also on that aspect.
Oh, okay. Now, Parvez, what are the different ways of monetizing your innovation, your ideas through IP protection?
Right. So especially coming into patents, and many of these are also applicable to other types of IPR, for example, design registrations or copyrights or trademarks, etc. So one way of monetizing or getting a broader term that we very often use is to commercialize or to make use of or to get some returns for, because the returns may not always be in terms of you get paid a certain amount. No. Okay. It could be you get paid something or you get some business advantage. Okay. Or some other asset or something like that, or some right or something like that. Okay. So it's not pure cash. It could be these aspects also you get paid in return. So one way of commercializing the patent or the IPR that you create is to use it yourself. Your company yourself is using that patented technology, and you don't allow others to use it. You don't license it to others. You don't sell it to others. Only you can incorporate that particular improved technology into your product. For example, if you're a washing machine manufacturer and you improved some part of it, the motor of the machine, only your washing machines will have that improved motor and give better results compared to your competitors' washing machines. They are also selling washing machines. You are also selling washing machines, but they don't have access to your patented technology for the motor. So their motors will be little less than yours. Therefore, you'll have a advantage in the market, in the sense, if anybody wants that good performing washing machine, they have to come to you. They can't go to your competitors. So one way of commercializing it, using the technology yourself. The second way of commercializing technology is to license the technology to other companies who may want to use it. Now, you may yourself be using that improved part or technology, okay, or you may not be, right? In either case, you can license the technologies to other companies who may want to use them, because they see you've made this technology, it's very useful. The users like to have access to that additional feature or that additional improved part, right? So they are interested in using, then they can't start using because you have a patent. I have a patent, I have a right to stop others from copying my improved technology without my permission. So they'll come to you for permission. And why will you give them permission? If they give you something in return, maybe they'll pay a license fee based on how many such machines they are selling. Okay. So in return for that, you will allow them to use. Now, when it comes to licensing, there are two types of licenses. One is exclusive license, means you license only to one party and to nobody else. So the party who's taking the license from you knows that only he, apart from you, or maybe not even you, can offer this technology in the market. Then they'll pay higher license fee because it's exclusive to that one company or one party. Or there could be non-exclusive licenses. So you can license this technology to many washing machine manufacturers, right? And each of them will pay license fee depending on their sales, but each of them will pay at a lower rate because it's not been given exclusively to them, right? This is how it works. A third way of commercializing is this intellectual property right that you have created. Either it's a granted patent or granted IP, or it could even be a pending application, a pending patent application. It's an intellectual property. Property means it has other characteristics of other physical property, like it can be owned, it can be transferred, it can be licensed, it could be rented out, it could be bought, sold, all kinds of things. It could be used, right? Like any other property. So in this case, one of the things that you could do is you can completely sell off this intellectual property asset, which is in the nature of a patent right, say for example. You can sell it off to somebody else. In that case, what happens is after you sell it off, you get your money, the deal is done. Then you don't have any more ownership right on this property or this idea or this technology or the patent, and all of that is exclusively transferred to that party. They have full ownership rights on that, and then even maybe unless there is a specific clause mentioning, even you can't use that technology or that idea after that. So it's complete transfer of the asset. It's like, suppose somebody has a house, there are two things the person can do. One is the person can rent out the house to somebody to stay for a year or a 2 year, and the person pays monthly or quarterly rent or something like that. In this case, the ownership of the property, the house stays with you, and after a period it will be in your possession also, right? On the other hand, if you sell off that house to the other party, you will get your compensation, your money, and after that even you can't enter the house. It's like ownership rights is completely transferred to the other party. Okay, so even in patent rights or IP rights, same thing, same concept applies. Okay, other than this, there could be certain other things like cross licensing. If I have a technology which I have patented, which others need, and somebody else has a patented technology which I need, maybe then we could do a cross licensing deal there. Okay, so these kind of things are also possible when it comes to monetizing the technology.
Wow.
Or
Okay.
commercializing it.
My next question will be, how is the valuation of the different types of IP assets are there?
Okay, this is a very interesting and difficult question to answer. It's difficult not just for me, but for anybody to answer. Okay, when it comes to any IP, it's very difficult to imagine what future value it will have, what will be the future demand, because the value of it will come in the future. You can't predict the value of it. Okay. Uh, our firm, Khurana and Khurana, as well as other firms, they might even do valuation exercises for your intellectual property rights. Okay, but those exercises are based upon certain assumptions about future value, revenues coming in, license fee, or you'll be able to sell it to this party or XYZ for this much amount. It's based on certain parameters which are assumptions, right? So any value that is calculated out of this are as good as the assumptions that you make about the future, right? So any value that you calculated is not the actual value, I'm telling you. It's not the actual value. It is just a calculation that you have done where you have taken certain parameters, certain values, and that's how it actually comes out. Okay. Other than that, as a practice, especially for patents, there are certain approaches very often that are followed. Okay. It is one is the related to the cost-based valuation. How much will it cost? We have made this kind of an asset, right, intellectual property, something like that. Now, if somebody else were to make that kind of a thing, how much would it cost to actually get that replacement value? That could be one way of looking at it. Okay, that could be the value or considered to be the so-called value. I'm saying so-called, not the actual. There's no real value to it actually, right? So that is one approach, cost-based approach. Second is market-based approach, right? Which is you estimate that this thing, what kind of market does this kind of technology have? In what product will it fit? What in that product, how much value this has, and how many units of that product will be sold? Then you will try to determine the based on that how much license fee can we collect on this over a period of say 5 years, 10 years, or 15 years, whatever it is, and try to determine that kind of thing. Okay, so all these things, can you see market value based or future revenues based? These kind of approaches are there, but these are just calculation based on certain assumptions. There is no truth to these kind of values. But sometimes you have to do these kind of valuation exercise based on revenue expected, or somebody says इसका similar products है तो इसका उसका market value इतना था, ये उससे 10% better है तो इसका market value उससे 10% ज़्यादा होगा. These kind of all kind of things are followed, but there's no real what should I say, truth to these kind of things. Now, the real actual value of an asset you can actually find out, okay, only at one point, which is when you actually have a deal that you have signed and it is executed and you sell off the asset and then you get the money in your bank account. Now, when you get that actual money in your bank account, okay, and you've transferred the asset, that is the actual precise true value of that asset. Other than that, there is nothing. For due diligence purposes, you can use these approaches and calculate the value, but they are just calculated value done for a certain reason. Because अब सब समझो आप एक कंपनी बेच रहे हैं या कोई डिवीजन हाई ऑफ कर रहे हैं और उसको सेटअप सेपरेट कर रहे हैं टू पार्टनर विद सम अदर कंपनी कोलैबोरेशन में जा रहे हैं. So you need to have some value. So you do these calculations, but they don't have any truth associated. They are calculations done for business reasons, right? Only value you get is the day you get money. And आपका पेटेंट का 20 साल का टर्म खत्म हो गया, आपको कोई पैसा नहीं है, so value of that patent is exactly zero. Okay, cost was say maybe 5 lakh rupees to develop the technology, get the patent was 5 lakhs, and you get paid zero revenue. So actual value of that is minus 5 lakhs. Plus you can add on interest to that. So that is the actual value. Where valuation is very difficult and commercialization is very difficult.
Okay. Now my next question will be, how does one bequeath in a will the IP assets, IP rights to his family members?
Okay, so I'll take the question as how does one bequeath or transfer these assets to family members? Because will is one way of doing it, transferring. Your interest is in transferring to family members or whoever you're interested in.
Any other way, yeah.
Right? Okay, that's the whole concept. So I have a very simple and short answer for this, fortunately. Okay, when it comes to bequeathing or giving or gifting or transferring intellectual property rights like a patent or trademark or industrial design copyright, or it could be many other things also, right? The transfer or the requirements or the procedures or concerns are similar to, suppose you have a house, you need to transfer to somebody. Okay, suppose you have a car, you have to, suppose you have a balance in your bank account or a FD, or you have certain investments. How do you transfer? Same thing applies to this. This is the meaning of intellectual property. It's again a property, and just like all those properties you have to take care through these various routes, same thing exactly will apply for this, right? There is no difference in that sense. So other than that, I have nothing ke IP mein aise karna hota hai, etc. When you apply and see in the patent application itself, you have to mention when you file the application, who's the inventor and who's the applicant. The applicant is the person or the entity or company which has ownership right. Normally, the inventors by default can become the applicants. I have invented and I am also the applicant and owner of this technology and patent. Very often, if the applicant is done a work for hire or he's employed with a company or somebody is paid them or later on they have transferred to some other entity, the inventor may not have ownership rights, but the applicant may have ownership rights on this. Okay, this one has to understand. In a patent, inventor doesn't have ownership right unless the inventor, him or herself, is the applicant also. So there could be these different entities. One thing to understand. Now, some of the inventors, what we have seen, what they do, okay, keeping in mind the future, and they want this asset to be transferred to their family members or whoever they are interested in, right? What they do when they file that, they have come up with the idea, they are the inventors, and their name is mentioned in the application as the inventor. When it comes to putting the names of the applicants, by the way, you can have one or more applicants, which could be individuals, it could be an institute, it could be an organization, it could be a company, whatever, right? Anybody can be an, or any entity can be an applicant. What they do, keeping in mind this future, I want to pass it on like this, is they might put, for example, parents, okay? If the inventor is a parent and they have children, okay? They might put the name of all the children. Or if it's a lady inventor, the lady inventor might put her husband and children's name there, right? So that to quite an extent, already the children have ownership rights on that in a certain way, or they might put their own name plus whichever family member they want, they put their name there. Okay. Now, if you want if to further divide, okay, this son will have this much right and that son will have this much right, not equal or something like that, you can have a separate agreement which mentions these aspects. So this is how you can, transfer or bequeath or make sure this reaches certain people that you are interested in.
Wow. So now, Parvez, according to you, what trends are you observing in the field of intellectual property law in India and globally?
Okay. Largely, I'll talk about India. Quite an extent, it applies globally also. Okay. And I would like to talk about trends that I see, trends that may need to accelerate, and certain trends that we see which might be good if they go down. Okay. In general, what we see in India and across the world is, especially when it comes to patents, the filings are increasing, whether it's other technology areas or even in the area of software technologies. Filings are increasing in the area of software. Obviously AI, ML, IoT, and blockchain or these kind of technologies, people are more and more interested in filing applications. By the way, AI stands for artificial intelligence, ML stands for machine learning, IoT stands for Internet of Things. Okay. And blockchain is a technology for keeping track of certain assets in electronic form, and it's basically a ledger system. Okay. Blockchain is a ledger system for keeping track of something without any failures or mistakes or missing links, etc. Right. I am very much against jargon, so that's why I'm explaining the terminology. Okay. So we see more and more patents being filed in this area. Apart from patents being, and this trend has been there last 2 decades or more, this is happening especially in India, because earlier the level of awareness on IPR and the patents and other IPRs being filed level was very low. Over the last 2 decades, 3 decades, it has, all these numbers have greatly increased. Along with that, another important aspect that comes up is more and more case law is available, whether in terms of whether this IP right should be granted or not. What are the factors? What is the opinion of the court on this? What do the judges say? How is a certain provision in the law interpreted? Case law is getting built up on this. One is on the patentability or registrability of the IPR. Second is when there are infringements happening. Somebody's got an IP registered and somebody else is infringing. Okay. What are the factors based on which the judge will determine is there an infringement or not? And if so, to what extent, and what should be the remedy and damages? So case laws are getting built up. This is very, very important, because when we started off, there was very little activity in terms of filing IPRs and very little case law in terms of what are the factors involved if there is a dispute or a disagreement or a rejection or there is an infringement. Very little case law. These are the trends that are happening. Okay. One of the trends that I see, which is there last several years, is lot of people, lot of educational institutes and lot of companies are filing more and more IP applications, especially patents, right? And this is a trend I want not to continue so much, because the reason why they are filing and what they are filing is problematic. The reason why they are filing is because they are chasing numbers. They want to show people that we have filed so many applications and maybe hopefully we have got so many, a smaller portion of that granted. So they want to, it's not that they are really innovating, coming up with new things. They really want to stop other people from copying, because they expect that people will copy, this patent will have a market value. That's basically the reason why you should be filing patents and IPR. But more people, a lot of people, this is a trend that we have seen over the last 5-10 years. They are filing because by certain authorities or for certain certifications, etc. They ask, have you got any IPR? What is your IPR portfolio? Or even customers ask, okay, are you an innovative company? All right. Do you have patents filed and granted on your technologies of your products? So because there is this external pressure in terms of you need certain numbers to show to outside parties, people are filing now, which is where very often in such disclosures that when we receive them, we see there is not much of an invention there really. Something they have done, which is an iteration or a variation, something new maybe, but not really innovative, but they say, okay, we want to file a patent because we want to show these numbers. Now, I hope this trend goes down. And when this trend goes down, just chasing numbers, the other trend I would like to see come up more and more. And this is happening. I want this trend to accelerate, which is people are very aware and conscious of what are considered as inventions. They become conscious firstly on innovating and improving their existing technologies and products. They come up with these ideas how this product or this system or this software could be better, and then they recognize it. They understand which part is the real invention and improvement, and then they file patents specifically on that inventive aspects, where because there is solid subject matter here, there is content here, there is a real innovation underlying. This is not for numbers sake, something you have taken and filing, but really you solved a problem that users of your products in the market were facing, which others had not solved. You solved it, and to solve it, you have come up with an improved part or a technology or a process. That is what you take and you patent it. That will have real market value, that has a better chances of being registered as a patent. And I hope this trend is increasing, this is happening, but I want it to accelerate more in the future, right?
Okay, now Parvez, how has technology helped you in your work?
What kind of tech are we talking about? Patent protection or just in general technology? Like a mobile phone is a technology, it helps
No,
me
no,
be
no,
in
no. IP
communication.
management software are the IP filing,
Okay.
tools which are assisting in your work areas.
Okay,
How is it
okay.
helping you?
That's an interesting question. Okay. One is such tools, technology and so-called tools, software system basically, they can help us keep track of applications and what's happening, what's the status, and what deadlines are coming up, so that we don't miss out on that. Okay. So these kind of, either we buy some, I specifically not very aware of what exact systems our docketing team has, but you could either buy some software which somebody has developed and use it in your company, or you could have your own system that internally you are using. Sometimes it could be based on Excel spreadsheets and such kind of internal basic systems, or you could buy it and keep track. Now these are, when it comes to the processing of the applications, etc., the formal requirements, those aspects of it, not really getting into like the subject matter of, or the content or the process of drafting the patent specifications or providing substantive replies to objections raised by the examiner when the IP application is being processed. Like they say your invention is not grantable, registrable as a patent because this technology already known, this feature is already known. That's a very substantive kind of thing. Now, in these kind of things, the question is there technology to help with this kind of aspect, whereby drafting of the patent application, any examination report that is received from the patent office where the examiner is objecting to grant of a patent on some technical grounds, these are the objections I have. Can there be some technology to help with that, right? Draft the replies to those, attend maybe even hearings on your behalf and argue whatever the examiner says, immediately you respond to that. The question is there technology available to do this? Now some people will say that yes, there is technology today, AI-based systems, like for example, Chat GPT itself. Like that, there are so many other technologies available, AI-based, right? But when it comes to actually using these technologies in our line of work, there are certain concerns which come up, right? And these concerns using such AI technology may come up not just in our line, intellectual property, but in many other lines of business also, okay? Firstly, whether whatever AI comes up with to this opposition or objection that the controller has raised, this should be the reply. Because if you put it to Chat GPT, I know it will give a fairly good looking reply. See that word I'm using. I'm saying, I didn't say good reply, I said good looking reply. Now that might actually be good, or it might merely be good looking, but the content of it might be totally, off track, off point. And actually the AI system, whatever it is, might be hallucinating. So that's a big risk. Suppose I use that to draft the application or reply, I'm taking a big risk, right? So can I take that risk on behalf of my clients? I don't know. Probably at this point, I would not do that. I don't know in future what will happen. Maybe our firm would probably not do that. I don't know for sure. But I can see the clear risk. Secondly, when we are dealing with IP applications, especially patents, now these are confidential technologies, inventions, new things, and the application details themselves are expected to be kept confidential. Okay, at least for a period of time. Now, if I take this and put it into the, AI based system, okay, this is my problem, give me the solution. Now my concern is where all with that information go? Who will decide? Who has control? Where will it sit? Where will it be used and where will it be misused? Can it come back to haunt us that the client says this thing which we have filed, which was given to you on a confidential basis, a friend of mine was doing this and he got this thing? No. Can we take that risk? Absolutely not. No firm, not just Khurana and Khurana, we as a firm, but any firm would not be, would not dare to take such a risk, right? So these are the basic concerns. Technologically, certain things are possible, but then there are certain concerns related to confidentiality, relevance, accuracy. All these issues are there, right? So this is where things stand as of today.
Wow. Okay. So, Parvez, how's the experience been in India regarding IP awareness sessions, knowledge sessions?
Okay. One thing I would say over the last 22 decades or so or more, the awareness level has increased quite substantially. The overall patent system, the patent office system, the patent laws have improved. The quality of the examinations have improved. When it comes to awareness, now whole ecosystem has to become more aware and improved. Only then it can't be only one part of the ecosystem which becomes more aware and improved and other. So all the different aspects of this ecosystem or parts of the ecosystem have improved, right? But even now, there is scope for much more improvement. In fact, I would say the level we have reached is not very high. It's still fairly low in terms of especially the general population or the technical people or the inventors or people who do technical work from where the inventions and innovations may come. There, the level of awareness is still relatively low, or even though much improved from earlier, right? People don't know what is an invention. They don't know if they suspect there is an invention I've come up with, how to describe it, what kind of drawings to give, what aspects to focus on, what should I describe in detail, what I should not describe. People don't know what is a patent, how should a patent be written, right? How should I describe it in a patent specification? By the way, a general description of how an invention works and what it does, it's very different from how a patent specification to get a legal right has to be written. These are two different things. Invention disclosure is different, a patent specification is different, right? What is a claim, how to write it, what kind of claim will give me a greater patent monopoly right? People don't have an idea. They don't have a sense of the importance of conducting a prior art search, okay, seeing what others have done, because this is a very common human tendency. Every inventor thinks this new thing that I have done, okay, is a great invention in the entire world, right? I didn't know about this. This idea came to me, 1 month back. So nobody in the world has done this. They assume this. Okay, maybe you haven't seen in your company or in your city or in your line of work in here, but maybe somebody else in Australia or in Brazil has already done this, created this idea and documented it or even filed a patent for it 2 years back or 5 years back or 10 years back. So you have to be aware of what's happening. You have to search things and be conscious of this aspect, right? And you have to be also be aware that patenting, IP protection is not cheap, easy or quick. It is resources intensive. It takes time, effort and money, right? When we say think about cost, what it involves, very often we talk about monetary cost. That is there, but did you notice I said it takes your time, critically important. It takes your efforts, your energies are diverted to that. Maybe if you are a business person, some of your energy will get diverted on the IPR protection side and less to that extent, less on the operations and your business, right? So it takes all of this. So awareness about all these aspects, very great big requirement to create more and more awareness on all these aspects.
Wow. Okay. Parvez, what advice would you give to young lawyers entering the field of IP protection of ideas innovation specifically?
Ideas in terms of what? I mean, you're saying young lawyers.
Protection of IP means young legal professional who want
Regarding
to.
IP, okay. So firstly, let me clarify that I'm not a lawyer myself. I'm a patent inventor. I'm a patentee. I'm a software inventor, in fact. Patentee. I'm also being an entrepreneur and I'm a registered patent agent. But the firm I work for, Khurana and Khurana, we are, lawyers. We are a firm focused on intellectual property law and related law. So we are a firm of lawyers. Okay, firstly. Secondly, any young people who are into law and they are looking at especially focusing on IPR law. Okay, what I would tell them is this is a growing area. It's a very interesting, innovative kind of an area. It has a great future. Next 10, 15, 20 years in India, this is going to just grow and grow because currently the size of this industry or the amount of activity and the filings, etc., even though they have grown to a large extent, very substantially over the last 20, 25 years, still then there is great scope for the numbers to increase and quality to be improved. And you are working not just with pure law, in isolation, which could possibly for some people be boring, but you're working in the context of technology and law. Also, not just technology, you're looking at technical aspects, you're looking at the business aspect of this. Okay, how to commercialize those aspects, where will be this be used, market, how do you optimize your innovation and your patent to the market and to business concerns. So it is a very interesting domain. You can have a great career in different ways in this, and it's a growing area which will continue to grow for a pretty long time.
Wow. Okay. So now let's go to the second round, the personal round, and let's understand Parvez as a person. So Parvez, tell us about your family and your formative years.
Okay, right. Okay, my family is originally from Mangalore, Mangalore area, which is in Dakshina Kannada district of Karnataka state, South India. So basically, we are South Indian family, but settled now in Mumbai. Okay, my parents were from there. I was myself born in Mangalore, but I've lived most of my life in Mumbai. So like Mangalore is my Janam Bhumi and Mumbai is my Karam Bhumi in that sense. Okay. My father was a cost accountant, and when he retired many years back, he was vice president finance in a medium-sized electrical engineering company based out of Mumbai Thane region. Right. My mother was a homemaker. My sister is a coordinator in the early learning center of an Australian school in UAE, United Arab Emirates. My brother is the executive director in Ernst and Young, EY. He's based in Gurgaon, right? And just as a piece of information, interesting thing, I would like to mention about my paternal grandmother. Okay, her name was actually Aziz B. Okay, she and her younger sister, they were one of the first ladies from the Muslim community to be trained as teachers, right? So for that training to be trained as teachers, they went from Mangalore to Madras in those times. Chennai, what we call today, was Madras. This was, about 100 years back, British times, right? So their entire family, including the sisters and the brothers, they shifted for a period of time, maybe about a year or so, to Chennai or Madras at that time, and they got trained by European teacher trainers as teachers, and then they came back to Mangalore, and that greatly helped with educating especially Muslim girls in Mangalore at that time. This is something that very much we remember and we are very proud of in our family, right? So this is the family background.
Wow. Okay. Now, Parvez, who's been a mentor or has influenced your life professionally and personally?
uh, Professionally, especially in the area of patents,
Mhm.
as I mentioned earlier. Okay, Dr. Vijay Pikesan, Vijay Panchapikesan is his full name in India, but in the he's like he was born here and he grew up in Mumbai. Okay, studied here in actually at a place called Surathkal near Mangalore. Now, actually, it is NIT Surathkal. Earlier, it was KREC Surathkal, which is Karnataka Regional Engineering College, Surathkal near Mangalore, right? He was educated there as an engineer. Then he went to the US, okay, and he studied, as a technologist. He was a researcher at IBM, and then he became a he became a lawyer and a patent attorney. And he was my mentor and patent guru. The things I've learned from him, I would forever, be grateful to him for that. I've learned a lot of things personally, if you see, from my parents, from my father and mother, who are very, focused, disciplined, hardworking people, very committed people, focused. Learned a lot from that. Apart from that, my brother, sister, my friends, some of my close friends, these people have been a big influence in my life. And very frankly, when I look at my life and I see my life is like a story of how many countless people have helped and supported me throughout my life, from childhood till today. So whatever I'm standing here is because of so many countless hundreds or thousands of people who have helped me in my life.
Mm. Okay. So, Parvez, how does the weekend look for you?
Weekend generally would be doing some work at home, or it could be even some office work. It could be maybe going out for lunch or dinner, or movies. Very rarely these days it happens, a little tied up, or just spending time at home with the family. I'm very interested in current affairs. So earlier it used to be fixed time kind of thing. Now you have it on your mobile phone, all the YouTube videos or other news, etc. I like reading, even though fiction and non-fiction also, history especially, I'm very interested, but get very limited time these days for reading. So, or we might visit some relatives or stuff like that, something like that. Yes.
Wow. Okay. Anything from your bucket list like you to do in 2024, personally or professionally?
Right now, by the way, we are getting our house painted, so that's like, it's upset the whole thing. I hope to get this completed soon, very nicely. Okay. Other than that, I want to continue making a difference in the field of IPR to help inventors and innovators, and also personally also, get the benefit and return in terms of the contributions that I'm making. So because this is a really an important aspect for me. This is one of the things that personally I would be looking at. Work in this area and also benefit personally from that also.
Wow. Okay. So my last question, describe Parvez in one line.
Okay. Okay, I'm a person who, likes to do things well the way they are meant to be done. And I am like, willing to help anybody, to the extent that is possible, whatever I can do. I would try to help people, whatever they need. It could be friends, colleagues, families, or even strangers.
Wow. Okay. Now let's have some fun, the rapid fire round.
Okay.
Uh, your favorite food dish?
Food dish, I would say prawns khata mirchi. It's a prawns masha. Prawns is a type of fish.
Mhm.
उसका एक खट्टा मिर्ची dish बनता है with aloo and all. So that is my favorite dish.
Wow,
I
thank
love prawns. Like Mangaloreans love fish.
you. Yes. Okay. Your favorite travel place?
My favorite travel place in terms of the historical kind of thing and how it impacted me was when I went to Aurangabad and I saw the Ajanta and Ellora caves, right? Those were amazing. It's some of the one of the things that touched me most in my life when I just visited those places. Even though one way work related नहीं है और मेरा personal ऐसा नहीं है, but when I saw those caves, and at Ellora you have that Kailash temple, that I feel everybody once in their life at least they should go and see the work that has been done in ancient times in our country. Just imagine, it has religious, spiritual, artistic, architectural, and historical significance. Amazing place. Even the Ajanta caves, set in that very unique location in a sort of a gorge or a river, small stream flowing by, and the kind of work that were done by our ancestors in terms of the paintings and sculptures so many centuries ago. It was totally like I was awestruck when I saw that.
Wow. Okay. Tea or coffee?
Tea.
Let's use a toast.
So even though coffee. So
Okay. Favorite piece of advice you have received?
uh, nothing comes as such. I think one thing which comes to my mind is uh, somebody, I think maybe one of my cousins told me, see, whatever you do, focus on that and do it well. Don't do time pass kind of thing. ये कर रहा है लेकिन मन से नहीं कर रहा. Don't do that.
Wow.
Which is
Your
something
favorite
I
color?
also agree with.
Yeah. Your favorite color?
My favorite color, I think purple.
Wow. So
Purple.
you did well, and you get this book
Okay, great. Thank you so
authored by
much.
me, and
Thank
it
you
will be
so much.
put to your place. So go
Thank you so
through,
much.
and there are different articles how for the Gen Z lawyer, and you are now, what do you say, multi-dimension facility. Sorry, you're wearing different hats,
Mhm.
and different hats of an inventor, entrepreneur, patentee, now
Patent attorney.
civil lawyer,
Yes.
patent
Attorney.
agent
Lawyer, I
officer,
won't say, but patent attorney. I'm a registered patent.
patent
So
attorney.
there is technology, there is business, and there is law, legal aspect of the protection. Yeah.
So
Which makes it very interesting.
yes. So thank you for a lovely conversation on IP protection, different aspects of your protecting your ideas, innovations, how this journey has contributed to your life, and in India, globally, you took us across different areas globally, how IP protection works. So friends, do watch this episode, which will be available on the Coffee Conversation Show, which has over 200 plus episodes. And if you have any great idea, innovation, Parvez from Khurana Khurana is a person to look out for. His details will be available on our YouTube channel. So subscribe and watch different episodes with different subject experts, how their journey they have gone through and contributed. Their contribution will help you to have change in your life. So we meet with another speaker. Enjoy your day, and we meet again over a cup of coffee. Thank you.
Right. Okay. So Ahmed, thank you so much to you for the opportunity, to you and your entire team for providing this opportunity and for all your help and support. Thank you so much. It's been such a pleasure.